Okay, thanks very much. Lovely to see all of you here. There may be two more people to come, but we'll get started because we're going to have lots to do today. Welcome to those who are joining us online. I can see you on my computer. And so what we're going to do is we'll have both the talk and the comment, and then we'll have questions at the end, I think, because it makes it easier to manage those, particularly as we have some online attendees. So we have two speakers today. First of all, we have Associate Professor Jorge Feliu, who teaches at Universidad Carlos III at Madrid. He writes and researches in areas of corporate and contract law. He's recently written, for example, on smart contracts, digital shipping documents, and escrow contracts. But today, he's focusing on penalty clauses, and he's comparing the development of the law in Spain with that of other countries, including English law. And then we have, as a commentator, Professor Hugh Beale. Professor Beale is Professor Emeritus at the University of Warwick. He's also a visiting professor at Oxford, and he and I used to teach together before I moved over here. He's a former law commissioner, and as you probably know, he is general editor of Duty on Contracts, and therefore is a very appropriate person to comment on this talk. So thank you very much indeed, Jorge, for your talk, and we look forward to it very much.
Thank you. Professor Gulliver, Stefek, CCL, Private Law Center, thank you very much for the invitation to participate in this seminar. It's an honor and privilege, especially when Professor Hugh Beale accepted the invitation by Professor Gulliver to be a discussion of my paper. Why the choice of this classic topic? Penalty clauses are, as we say in Spain, as old as the gospel and as new as the gospel. Penalty clause is always a trending topic. In this sense, there are several reasons to continue discussing on penalty clause. Some of them are in the slide. Let me only to read the following sentence of one of the leading cases here in England. In the opinion of some, should simply be demolished, and in the opinion of others, should be reconstructed and extended. As you see, this sentence explains everything. To talk about all the issues concerning penalty clause could take not hours, but days, even months. We have short time indeed, so I prefer to focus on specific issues, which in my view are some of the most relevant, and specific subjects, business-to-business transaction. In this regard, I will divide the talk in two blocks. The first one is the core of the talk, and my intention is to present a series of reflection in relation to the concept, effects, and moderation validity. The second section, if we have time, contains some brief reflection about the impact of the technology in this type of clause. Before I start with the first block, let me give you an example to which I will refer throughout the talk and that I use in my lecture with the students to explain various subjects. For example, commercial law and contract. Imagine the family, Rumbao family. They are funding family and one of the majority shareholders of the bank. They individually have a percentage in the company that, let's imagine, does not allow them to appoint member of the board of directors. But all of them together can appoint 4 of the 15 board members. Imagine that for this purpose, they enter into a simple voting syndicate, a shareholder agreement, whereby they have to vote according to the guidelines of one of the members of the family, David. One day of the annual general meeting, one of the family members, Maria, breaks the shareholder agreement and votes against David's instruction. And instead of appointment 4 members of the board, he can only appoint 3 of them. Among others, what can Rumbao family do? If we turn to the general remedies in some civil law system, we will see that they are of little of use. The first of the specific performance, this is the family wants, and the parties to a contract are more interested in, pacta sunt servanda, that the contract is performing in all terms, but it is not feasible. Signed agreement in some specific civil law jurisdiction is unenforceable against the company. Termination. Termination of the contract is not the interest of the David Rumbao and the family. they want and need to keep the stakeholder agreement. Damages. The problem here is how we calculate the damages caused by the loss of a member of the board. Therefore, the agreed party interest is, in this particular case, that the contract is fulfilled on its own terms. It's not interested in the termination of the contract or possible compensation. And it is not possible, or in addition to the above, compensations will be easy to determine and to obtain. In short, immediacy and enforceability. As you know, one of the instruments that the law provides us, among others, is the use of penalty or liquidated damages clause. But what is a penalty clause or liquidated damages clause? Broadly speaking, and we enter in the backgrounds, the basis in almost all countries is the same. Its common denominator you can see in this definition that we can summarize this saying, in the event of non-performance of a certain obligation, the parties agree that the obligor must perform a certain obligation. From this general definition, we can observe the difference, which have gradually been diluted in some cases. In this initial part, we will observe this in relation to the nomenclature, the type of obligation, and if the secondary obligation only is triggered by the non-performance of the primary obligation. Let me start with the first one, with nomenclature. In common law, as you know very well, and specifically here in England, we can see the distinction between liquidated damages and penalty clause. The former is enforceable and the latter is unenforceable. When are we dealing with one and where are we dealing with the other? Leaving aside the historical origins, the traditional distinction has been based on the genuine pre-estimate damages. For that purpose, we applied the law damages for test. This test achieved the status of a quasi-statutory code in subsequent case law. And this test is the only one that is still applied in some common law jurisdiction like Singapore. But there are also began to other decisions where, in order to be valid, a clause didn't need to be a genuine pre-estimate, as long as it was commercially justifiable. And its dominant purpose was not to dissuade the other party from non-performance. We can see now how it's moving the line from genuine pre-estimate test to non-genuine pre-estimate test. It's moving from liquidated damages to penalty clause. The big change, or the confirmation of the existing trend, came with the Cavendish and Parking Aid cases, where the deterrent proposed is now accepted as long as a series of requirements are met. There must be a legitimate interest that justified it, and the amount impalpable or the consequence is not extravagant and unreasonable to that interest. We can see now how the line is moving further from liquid damages to penalty clause, including now as under liquid damages what used to be considered penalty clause. In civil law system, in general, the concept of penalty clause is included both concepts, liquid damages and penalty clause. Clause are valid whether the proposal is pure liquidatory or dissuasive, and in minor case, purely penalty clauses. But the tendency at the end is moving the line from pure punishment to a proportional legitimate deterrent. So both traditions are getting closer and closer. What has uniform law done? Initially, and in accordance with the resolution from 1978 of the Committee of Ministers for the Harmonization of Penalty Clause between the member states of the European Union, the civil law tradition was followed by using the term penalty clause to cover both liquid damages and penalty clause. But subsequently, this terminology has been avoided in order to seek a common position. Thus, the text of the Uniform Rules Constitutional of 1983 used the term agreed sum due upon failure of performance, but still mentioned in its wording both concepts, penalty and compensation. In the UNIRA Principles 2016, they tried to avoid its denomination opting for a more neutral and broad denomination and wording, opting for what some scholar has called it a neologism, agreed payment for non-performance. This concept includes the traditional liquidation clause, such as a penalty clause, but without mentioning both terms. If we go back to the common denominator, we can see that the obligor must perform a certain obligation. What is the obligation to perform? This could be another bit different between the civil law and common law system, which I think, in my view, is also where a great approximation is taking place. In general, in civil law system, the penalty clause is generally a pecuniary obligation. But given the purpose sought, any obligation to give, to do, or not to do can also be the object of the penalty clause, as you see here: Italy, Netherlands, Germany, Argentina, Belgium, Colombia, and other countries. Now the exception perhaps is French law with the new reformation from 2016 that now say pay a certain amount. In common law system, the obligation traditionally consists of the payment of a sum of money. But according to the wording of the cases, it seems that it can also be another type of obligation. The question now could be, this possibility, another type of obligation, is compatible with the common law remedy system? If it is a liquid damages, then logically it will be pecuniary, because it's a pecuniary equivalent of the non-performing main obligation or of the economic interest of the unsatisfied party, equal interest or estimated rate. But when we are looking for other type of purpose, it's more logical to extend the type of obligation to other than purely economics. In the example given at the beginning, the penalty may consist of the payment of a sum of money, but also, depending on the effect we want to give it, we introduce other kind of obligation. Yes, the example: Maria sells her shade at the market price. Maria sells her shade with a penalty on the purchase price. Maria transfers an affected asset of the family. I'm going to explain this issue later. It is curious that in uniform law, from the very beginning, only the possibility of payment of a sum of money has been adopted. The last background issue is breach of contract. And here arise two questions. First one, are penalty clauses triggered by non-performance of the obligation? In majority of jurisdictions, yes. There are exceptions, for example, now Australia, where the case law Andrews versus Australia New Zealand Banking Group, the application of the doctrine of penalty rule is permitted only to case of breach of an obligation. The international instruments that you see here adopt the common position. Thus, it's also a common denominator that penalty clauses are triggered by non-performance of the obligation. The second question is, breach of contract must be attributable to the debtor? In general terms, yes, but in some jurisdictions, parties can agree otherwise. In the international instrument, we can see the evolution. The resolution of 1978 declared expressly that the liability of the debtor is a requirement. The UNCITRAL model rules declare the same, but let the parties agree otherwise. There is no express reference in UNIDROIT principle, but in the commentaries say literally that exceptionally, however, such a clause may be intended by the parties also to cover non-performance for which the non-performing party is not liable. Effects. Another issue that is important to discuss is the effect of liquid damages and penalty clause. In principle, we can differentiate between intention, desired effect, and achieved effect. For example, my intention is that the contract we will fulfill. The desired effect, ex ante, is to deter non-performance of the contract. And the effect obtained, ex post, may be to perform to the contract or to liquidate damages or punish for non-performance, depend on the secondary obligation. But to make it simpler, we will distinguish the effect by considering two parameters: content of the second obligation and time. in this way, in general terms, we can distinguish effect ex ante, ex post. Ex antes. The first function or effect, which I think is common to all legal systems, is to establish in advance the quantum of damages in the event of a future non-performance. The obligee does not have to prove and calculate the damages suffered, and the obligor limits its liability by knowing in advance the amount of damages. In this way, procedural problems are avoided, as well as the substantive difficulty of calculating, assessing, and providing damages suffered. I think here is called action on debt, different than action on damages. No? Therefore, the first effect will be the valuation, liquidation, or substitutive effect. The second effect is more problematic and is where the system differs more. In general, currently, in some common law tradition like England, is open to this effect, provided that it meets certain requirements, as I said before. One exception, for example, Singapore, who maintained the traditional view as you can see on the screen. On the contrary, this type of effect is more common in the civil law tradition. In my view, the main difference between the two systems is based on the different understanding of the principle of pacta sunt servanda and the possibility to exercise of a specific performance. Because in civil law system, in general, you are not free to change your mind and break your contract obligation when you wish, even if it appraised. Damages in common law system is the main remedy in contract law, and a specific performance is exceptional at discretion of the judge. Therefore, and it's my opinion, the deterrent effect must play an important role at common law. It may be the last opportunity for the obligee to perform the contract on its own terms. In the civil law system, on the contrary, if you breach the contract, the creditor is entitled to a specific performance. International instruments in general adopt this vision from the civil law tradition. In relation to the deterrent effect, there is different rate of it. As a starting point, and from my point of view, liquidated damages also has, in some cases, a minimum deterrent effect, as I do not have to quantify it and prove it. Also, there is deterrent effect when the debtor doesn't have enough liquidity to pay the amount in case of breach of contract. From this point, the effect may be greater or lesser depending on the configuration. In this respect, two aspects should be taken into consideration: the type of secondary obligation and if the penalty is not liquidatory but cumulative. The first one, the type of secondary obligation. In the example given at the beginning of the talk, for Maria, paying a sum of money may not be a deterrent since she's rich. I give you 1 million, pues for tip, another million. But selling her market value bank share with a penalty might be more dissuasive. Moreover, the loss of an asset of great sentimental value to her, an asset of past generation, a cuckoo clock, maybe have an even greater effect. Therefore, deterrent in some cases is better achieved with other types of obligation than to pay a sum of money. The second, if the penalty is not liquidatory but cumulative. Cumulative in two different senses. Add to the penalty the unliquidated damages, add the penalty the performance of the obligation. And this is possible in a few civil law traditions and now in the uniform test. And you can see in the slide, in the resolution from 1978, this was not allowed, but in the uncitral text, the parties could agree to do so. What are the exposed effects? Depending on the content of the clause, we can find 4 effects. The first one is penitential effect, is when the obligor is given the choice between performing the obligation or paying the penalty. This type of penalty, also known as multa penitentiaris. In my view, this is not a penalty clause, but an optional obligation, because the debtor can choose. Risk insurance, I have already referred to in relation to breach of contract and its relation to the debtor liability. And compensatory, everyone knows this effect. In this respect, it's interesting to recall that liquid damages will be the pecuniary equivalent of the primary obligation. For this reason, it is not possible to obtain both performance of the primary obligation and the fixed amount at the same time, unless that the amount has been agreed for a delayed performance. The exception in some countries and the uniform test is if the agreed sum cannot reasonably be regarded as compensation for that failure of performance, the obligee is entitled to both performance of the obligation and the agreed sum. Other ways to obtain this are moderation of the judge, for example, in French law, the swap, to increase the amount when it's the swap. Claim damages, the creditor may claim damages to the extent of the loss not covered by the agreed sum if the loss substantially exceeds the agreed sum, or the last one, being treated from the perspective of the limitation or liability clause. That I think that is here is one of the ways that is possible to use in England. And the last one, and it is the big difference between different legal traditions, the punitive effect. Of course, we can speak a lot of time about punitive effect, but I only here arise two questions for me because we don't have time. The first one is, everything that is not compensatory is punitive? From my point of view, yes, in two senses, economic and intentional. Economic, liquid damages are in broad sense, the pecuniary equivalent of the primary obligation. Anything more is enrichment, unjustified or justified. Compensate at the end is to balance in opposite direction the effect of one thing with another. Intentional. If the performance of secondary obligation does not compensate my interest in the fulfillment of the primary obligation, could be punitive. It is not the value of the property that matters, but the intention sought in the performance of the secondary obligation. In the example of the stakeholder agreement, transferring a sentimental asset of Maria because David knows that it deters her from not fulfilling the contract is punitive, because David is not interested in the asset, nor is he compensated for the damages caused. He's interested in penalizing the other party for non-performance by taking away the asset to which she is bound. The second question is, does the deterrent effect when the contract is breached become punitive? With the breach of contract, the desired effect disappears and the achieved effect appears. The question now is what I have used as a deterrent. And now we take the answer to the former question. If it's not compensatory, punitive. In this sense, does the Cavendish doctrine hide a penalty clause in the civil law sense? From my point of view, the fact that a clause has a punitive effect does not mean that it's unenforceable per se. The presumption should be validity and enforceability. The question now is when the punitive effect is unenforceable or null. In order to try to answer these questions, we must address the last issue, moderation. Moderation is another important issue in the penalty clause discussion. I can talk about different aspects of moderation. I would like to connect it to validity. Moderation and invalidity are sometimes two alternative solutions. From my point of view, in some cases, moderation is a strategy to prevent the invalidity of the clause. Let me explain. In general terms, we can see three different scenarios. I have tried to summarize the three scenarios in this slide. It's a little bit difficult, but I try. It's from a cynical point of view. In the first line, we can see countries where moderation is not possible because penalty clause is unenforceable and invalid, like Singapore. The second line, we can see countries where liquid damages and some penalty clause, included here England, are valid. But if it crosses a certain line, it is unenforceable and invalid. In principle, there is no reason for moderation the clause is subject to validity criteria ex ante and ex post, or contract law general policing doctrines, contrary to the law, public order, moral, usury, abuse of rights, fraud, arrest, etc. Some countries in this line, like Spain, following the old tradition, moderation is only accepted in one specific case, where the clause is agreed for total non-performance, and the non-performance is partial, fairness reason. In the third line, we can see countries following 19th century trends, most of them, and where the moderation by the judge when the penalty is manifestly or grossly excessive. Here, when you trespass the line, instead of subjecting the clause to a judgment of validity, the judge proceeds to moderation. This means that the judge has the power to rewrite the clause in order to make it valid, with the resulting consequences. From my point of view, and it's a personal opinion, of course, I prefer the second scenario, validity instead of moderation, because the parties will be more careful in drafting the clause and seek to balance their interests and protect the parties' autonomy. Some consideration arise in relation to moderation that I leave here. First, the obligation should be pecuniary because of the difficulties in moderating other type of clause. We return to the national example with the breach of shareholder agreement. Can the judge moderate the number of shares to be transferred or the transfer the affected asset of the family? Second, what are the criteria to compare with? In the initial example, how do we quantify the loss of a member of the board? If it's not possible, how can we assess in the amount or other obligation it excessive? Third, it encourages one of the parties to increase the penalty by knowing that it can be moderated. Something similar happened with the effect of the abusive clause when some legislation led to the judge moderate the content of abusive clause. The European Court of Justice declared that if the effect is nullity, no moderation was possible. Otherwise, it will be to the benefit of the company. The final consideration will be deterrent effect greater with moderation. As you can see in the slide, uniform texts follow the scenarios and take the actual loss as a reference, and in the most recent uniform test, add other circumstances. And as you can see in the slide, some consequence of moderation may be, in some cases, arbitrariness, more disputes, and higher costs. To conclude, some reflection on the impact of the technology on liquid damages and penalty clause, very briefly. From a static point of view, the technology through a smart contract can, in some cases, help determine and specify the penalty as well as its legality. In the first example, automatically transfer the share and calculate the price. Or also, in those countries that have a calculation or benchmark system to know when an interest rate is usurious, technology can help. From dynamic point of view, the technology through a smart contract can help in the enforcement and increase the deterrent effect. But some problems arise in relation with the limits of the self-help remedies. Conclusion. I perceive a rapprochement between civil law and common law position in relation to this topic. In some countries of common law tradition, there is a change from pure liquidated damages towards a broad concept that embraces the concept of penalty clause in civil law. In civil law tradition, there is a change from pure punitive penalty clause to more reasonable penalty clause. In this sense, both traditions are uncomfortable with the penalty clause. Therefore, it is necessary to make a case for finding a new logic for liquid damages and penalty clause that will facilitate harmonization in business-to-business transaction. A simple change in the terminology is not sufficient. I think that there must be a presumption of enforceability of this clause. Instead of moderation, the clause shall be subject to contract law general policy doctrines. But the root of the difference and the problems in relation to these issues is in how the principle of pacta sunt servanda is understood, the freedom of contract, and the condition of exercise of the remedies. Thank you very much.
Thank you very much indeed, Jorge. Very, very interesting. Lots of food for thought. But I'll now hand over to Hugh, who's going to comment.
Well, Jorge, thank you very much for a fascinating paper. All sorts of things that I'd never thought about, and indeed some documents I'd never come across before. The UNCITRAL thing, I was completely innocent of that until we talked on Friday. I suppose it's natural that I will approach this from the point of view of a common lawyer. And what I thought I might do is just to list some of the points which I found to be particularly interesting and that we might discuss. And because we haven't got very long, and because I hope we'll have some discussion, I'm not going to do more than just skim over some of these points. But you can see that I've got a list, and I'll just run through them very quickly. The first question really is, are we talking about a system which is basically aimed at compensation, or one that's aimed at punishment in the sense of trying to make sure that there is an adequate incentive that the other party actually performs the contract? And as you said, in some jurisdictions, we're stuck on the genuine pre-estimate. And in other systems, however, it appears to be perfectly okay to penalize the other party if they do not perform. I would say that English law is now sort of halfway in between, because my understanding of the Cavendish decision is that you can only have something which goes beyond a reasonable pre-estimate or genuine pre-estimate. And obviously there's flexibility because it mustn't be much more than a genuine pre-estimate, but it mustn't do that unless you've got some legitimate interest in forcing the other party to perform rather than claiming damages. And it seems to me that that means that damages must not be an adequate remedy for some reason, either because it's hard to prove causation or hard to prove the amount of loss. The only exception to that is where you have a scheme, rather like the scheme in Dunlop and New Garage, where quite simply you need to police the scheme, and the only way to do it is to penalise people who break it. But what I understand that you can't do in English law is simply to effectively create a private system of specific performance, just because you would prefer performance to claiming damages. You've got to show somehow that damages would not be adequate. So I think we're still linked back to the notion of compensation. So other systems don't seem to do that. So one question which we'll have to come back to is to what extent they are moving away from pure punishment towards some kind of deterrence. There are obviously different types of clause, and I don't think we need to spend any time on that, but obviously in English law, we get into particular problems when the clause says if you break the contract, you will lose either a sum of money you've paid or you will lose some existing property right. And there we get into the doctrine of forfeiture, which frankly, I'm not going to talk about because I don't understand it. Maybe Jonathan or somebody can help me out on that. We've got the question of the trigger. Obviously, breach of contract normally triggers a clause, but in the Andrews case, it's sums payable on other events. Also in the Cavendish case, they said there might be something which was a disguised penalty clause. In other words, something which doesn't appear to involve a breach of contract, but in practice is a penalty clause. That's something that Lord Bingham mentioned in the Interphoto case. They mention it again in Cavendish, and frankly, I have no idea what Bingham meant. And I don't think the Supreme Court did either. I think they mentioned it out of politeness, frankly. But then we have this other problem about the majority decision in Cavendish, which say that even if there has technically been a breach of contract, if this was a primary, not a secondary obligation, it's not subject to control. And frankly, I have no idea what that means either. I don't know how you identify a primary obligation if it is something which is only coming into effect when there's been a breach of contract. To me, that is a secondary obligation. But never mind, that's just an English problem. Then we get the question about sums which are payable when the defendant is not responsible. Now, as I understand it, some systems in which liability for damages is fault-based or where force majeure is a defense, you can agree that the sum will be payable even though normal damages wouldn't be available. Now, that just doesn't arise in English law, partly because we're normally talking about strict liability anyway. But secondly, when we have a force majeure clause, it's nearly always coupled with an extension of time clause, which is there to say, effectively, even if the other party holds you up, you can still claim liquidated damages. They can give you extra time and thereafter claim liquidated damages. And I have to say, I'm not quite clear what the purpose of these continental rules is. I can't really envision when they'd be used, but maybe Jorge can come back on that later. Then there's a question about penalty plus specific performance or plus damages. I can quite understand that somebody can claim specific performance and a penalty for being late or damages for delay, but both Spain and UNCITRAL seem to allow damages for other losses, and I begin to wonder what's the point of the penalty in that case. Except that if you are really saying that a penalty clause in the Spanish or other tradition is quite simply a punishment and nothing more, then I suppose I can understand that I should be punished and I should have to pay compensation. But that, to me, is a pretty foreign notion, if I may say so. We do, of course, allow penalty, a sort of penalty in the sense of a deposit plus damages in English law. I have to say, I'm not quite sure why so many systems seem to allow both a penalty clause and damages. And I'm wondering whether actually the problem is one that we would deal with differently. The problem is that the penalty clause may not cover certain types of loss which the parties hadn't thought about when they drafted the clause. And of course, we've got a recent case about that, the K-line case, about whether demurrage damages are supposed to cover just the loss of profitability for the owner of the ship, or whether they might also cover deterioration of the cargo. But this is the area I want to talk on. Moderation. We saw that if the sum is too low, a French judge can increase it. I assume, and I think, Jorge, from your slide, you must think the same, but what we're really dealing here with is a kind of limitation of liability clause, and it's an indirect way of challenging a clause. Probably no longer necessary, actually, in the French system, now that they can strike out clauses left, right, and centre anyway, at least standard form clauses. But if the sum is too high, it seems to be pretty widely accepted that it can be reduced. And I understand many systems operate a sort of dual system. They ask, first of all, was this intended merely as compensation? And then you, as it were, reduce it if actually it's overcompensating. But where it was intended as a deterrent, as a punishment, it still apparently can be reduced on the grounds that it's excessive. But by what criteria do you judge whether it's excessive? If you allow pure punishment, it doesn't have to be linked in any way to compensation. And it seems to me that unless that reduction for excessiveness is actually meaning the court will only do it when they think you should get compensation of some kind, but for some technical reason you can't get it. Unless that's what's happening, I think we are still quite a way apart, civilian and common law. But the other issue is about the moderation in terms of what date do you moderate? In English law, we've had the question of if I've put in a clause which is more than a genuine pre-estimate, can the court rewrite the clause? And in Cavendish, they said, no, you can't. But what's happening in other systems is that it's ex post facto moderation. You actually look at the situation in the light of the actual loss that the claimant covered. And that, of course, is something which was rejected very soundly back in 1915, 14. Jonathan will correct me. A case called Clydebank Engineering and Castaneda. Have you come across this one? Jorge, you ought to know, because this is a contract between a Scottish shipbuilding firm and the Secretary of the Spanish Navy. Contract for gunboats. And there was a penalty clause for late delivery. The boats were delivered late, And the secretary claimed the liquidated damages, and it went to the House of Lords on the argument from the contractor that the Spanish Navy had lost nothing, because 2 days after the boats should have been delivered, the Spanish Navy was engaged in a disastrous battle with the Americans, and every single boat in the Spanish Navy was sunk. So if the boats had been on time, they would have been at the bottom of the Atlantic. Therefore, and the House of Lords said, go away. But I think to an English lawyer, any notion that you're going to moderate the clause in the event of what actually happened is going to undermine the purpose of the clause. And I've left it in mid-sentence, what is the purpose of the clause? Now, Jorge, you mentioned establishing quantum and deterrent or persuasion. And of course, those are recognized everywhere. But I think most English lawyers would probably say there's another one. It's all about risk allocation. Take a construction contract. If the contractor is subject to liquidated damages for delay, they can work out what the risk of delay is. They know how much they will lose because it is just the amount of the liquidated damages. And therefore, they can price the risk and work out how many spare resources do I need to have in place in case things go wrong. And very often, the employer, of course, will cover the rest of the loss. And very often, the liquidated damages are fixed at a figure well below the actual loss that will be suffered by the employer. They're what we call under-liquidated. And basically, all the way through our law, you'll find that the English courts are very, very reluctant to undermine what they think the parties have done by way of risk allocation. And that leads me to my last point about really the role of the court. I still think we have a major difference between the common law systems. I forget about the Americans because they've been doing their own thing for years, but at least the traditional common law systems and the civilian systems. Many civilian systems seem to me to be very concerned with equilibrium of the contract, that it mustn't be too unbalanced at the beginning and it must be kept balanced. Whereas the common law, basically, the judges will say, our job is simply to hold people to their agreement. We're not concerned with equilibrium. We'll only interfere on set grounds. Now, of course, you have set grounds for interference in the civilian systems as well, but there are far more of them. The common law interferes very, very seldom. So we get a whole series of differences in doctrine, which I think represent differences in philosophy. Duties of disclosure, controls over general conditions of contract and B2B contracts, which we barely have, and of course, change of circumstance. Okay, so in English law, what happens if you miscalculate, if you make a bad deal? Well, basically the answer is tough luck. If it's really bad, you'll become insolvent. But our law of insolvency is very generous because you can start up again very quickly. And that's the way we solve many of the problems that you solve by rebalancing the contract. So just some thoughts, but thank you very much.